Go.
Hello there. I'm out in the hallway right now, and if the hall monitor were to catch me, he'd accuse me of not having a pass, and I'd be sent to the assistant principal's office where I'd be questioned. But I know my criminal trial rights, and I know that I won't have to say a word without having a counsel here. Because right now we're going to go research my criminal trial rights. Let's go. So before we start researching some of these great cases, I think we should understand what criminal trial rights are. And according to Webster's dictionary, criminal trial rights are the framework of laws and rules that govern the administration of justice in cases involving an individual who has been accused of a crime, beginning with the initial investigation of the crime and concluding with an unconditional release of the accused by virtue of acquittal or by the imposition of a term of punishment pursuant to a conviction for a crime. And this means that during the trial you have your right to counsel, also described in Webster's dictionary as the legal responsibility for the government to provide every defendant in a criminal action with legal representation that also must be deemed effective, which we will see come up in a couple of our cases. And it also says that you must have the right to an impartial jury, which every criminal case must be presented in front of an unbiased jury. Okay, yeah.
Go.
Oh, hello there. Sorry, I'm just busy researching the first criminal trial case that we have here. It's called Powell vs. Alabama, and it was in 1932. The background of this issue is that 9 black young adults were accused of raping 2 white women. 3 trials took place in one day, and they were sentenced to death, even though the doctors testified that these girls had never been touched or raped. But who cares? Because an out-of-town attorney came in to represent them, but could not formally represent them. So, although Alabama law required the appointment of counsel in capital cases, all the lawyers around town refused to represent them, except one. The attorneys did not have the chance to consult with their clients, and they had done little more than appear to represent them during the trial, and they had no opportunity to investigate the case. So the question that's being asked here is, did the trial violate the Due Process Clause of the 14th Amendment? The answer is yes, because in a 7-2 opinion given by Justice George Sutherland, the court held that the trials denied the Due Process Clause of the 14th Amendment because the defendants were not given reasonable time and opportunity to secure counsel in their defense. The significance of this case is that the case was an early example of national constitutional protection in the field of criminal justice. All citizens must be given a fair trial in criminal cases, which includes giving the defendant time to investigate the case thoroughly and prepare an argument with their clients. Now, the policy impact here isn't a very big one. It's just that all courts now have to heed into the Due Process Clause. It's not really a policy, it's just something that they have to do now, which state counsel must be guaranteed to everyone facing a possible death sentence, either in state or federal court. That's pretty much it.
Go.
This is very interesting. The next case that appears here in criminal trial rights is Gideon versus Wainwright in 1963. The background here is that Clarence Gideon was charged in a Florida state court with the felony of breaking and entering into a pool room with the intent to commit a misdemeanor. Gideon requested that the court appoint a lawyer for him when he appeared in court, but he came without one. The Florida state law stated that a lawyer can only be appointed to an indignant defendant in capital cases. Gideon then represented himself and was found guilty. He then filed for a habeas corpus that his Fifth Amendment rights had been violated. The question is, does the Sixth Amendment's rights to counsel extend to felony defendants in state courts? Conclusion here is that all the judges ruled in favor of Gideon. They found that the framers put high value on the rights of the accused to defend themselves properly. It was also required by the Constitution that state courts must appoint a lawyer to those who could not afford one. So the impact here is that it allowed for both sides to have proper representation of both sides of the case, and it also changed the workings of state courts to uphold the Fifth Amendment. I wonder what there is to steal. I mean, buy. Oh look, it's another criminal trial rights case. Pointer versus Texas, 1965. A man robbed a 7-Eleven store. His name was Pointer, won $300. He was searched and seen talking to someone named Dillard. They were both taken into custody, but neither of them had counsel present, and once the prosecution was started, Phillips was not allowed to approach Dillard, even though it was a witness that was very crucial in his case. So, did Texas violate Pointer's 6th and 14th Amendment rights by not admitting evidence drawn, and he was not represented by counsel, and he was not allowed to confront a witness? The answer is yes. He was supposed to be able to have the opportunity to confront Dillard through counsel. He was supposed to have counsel present, and in a 9-0 opinion, it was deemed that this was unconstitutional. So the significance is the case emphasized the importance of a defendant's rights to confront witnesses and described it as a fundamental right, as well as all courts are now required to give the accused right to confront witnesses and right to a counsel. Okay. Oh my god, I'm in jail, and I haven't even been read my Miranda rights yet. What are those, you ask? They come from the June 1966 Miranda v. Arizona case, in which the federal question being asked is, do the Fifth Amendment's protection against self-incrimination extend to the police interrogation of a suspect? The answer is yes. The Supreme Court held that the Fifth Amendment's protection against self-incrimination is available in all settings. This amendment requires law enforcement officials to advise suspects of their rights to remain silent and obtain an attorney during interrogations while in police custody, which should not happen to me, and I'm sitting in jail rotting. And this happened in Arizona when someone was arrested, not given his rights, and found guilty, and that's someone in Parker v. Gladden, December of 1966, was found guilty of second-degree murder. A bailiff was found gossiping to the jury, saying, "Oh, that wicked fellow, he is guilty," and to someone else, "If there's anything wrong in finding him guilty, the Supreme Court will correct this." Well, this was overheard by at least one juror member. So the question here is, did the bailiff's statement result in an impartial jury violating the Sixth Amendment? Yes, it did. I will have order in my court, and the Supreme Court reversed the decision of the Supreme Court in Oregon by deciding that the statements violated the command of the Sixth Amendment, made applicable by the 14th Amendment, that the accused shall enjoy the right to trial by an impartial jury, which was not given to him here because of those gossiping bailiffs. See this case right here? It's pretty sad, just like our next case, Washington v. Texas of 1967. And in this case, a petitioner and his buddy were both tried and convicted for murder, but during the trial, the petitioner was not allowed to use his buddy's testimony as a witness or give his testimony to anybody, and this violated what was that violating? The Sixth Amendment by not letting his co-participant testify. That was the question, and the answer is yes. The right under the Sixth Amendment of a defendant in a criminal case to have compulsory process for obtaining witnesses in his favors applies to the states of the 14th Amendment, so he should have been able to use his buddy as testimony or as witness, and the significance of this is the defendant must be given the right to have compulsory process for obtaining witnesses in order to testify to aid his defense. This next case is Strickland v. Washington of 1984, and in this one, some guy named Washington in Florida pleaded guilty of murder, but his attorney did not seek witnesses or even ask for a psychiatric evaluation because he might be crazy. And his argument here was that his Sixth Amendment's rights had been violated due to ineffective counsel system at the sentencing. Question here, what standard should be applied to determine if the person's Sixth Amendment right had been violated and require a reversal of conviction? Conclusion, Supreme Court ruled that the counsel's performance must be deficient and that such performance must have prejudiced the defense and resulted in a skewed trial. The court ruled that Washington's defense was not unreasonable, nor did it cause sufficient prejudice to pardon Strickland's death sentence given to him. Its impact is it defines standards that should be applied to decide the performance of appointed counsel violates a person's Sixth Amendment rights. Roper v. Simmons, 2005. Quite recently, Simmons, a young man, received the death sentence when he was only 17. So this is about criminal cases with underage children. He was given the death sentence, but the question here is, does the execution of minors violate the 8th Amendment of cruel and unusual punishment, and does it apply to the states through the 14th Amendment? In a 5-4 opinion, the court ruled in favor of upholding the Missouri court's ruling, which ruled that they would reconsider Simmons' case. They reasoned that since a majority of state legislators were against the death penalty for minors, as well as international opinion, they favored the removal of the death penalty. Policy impacts, by using the popular opinion of state legislators, the Supreme Court progressed the elimination of the death penalty because the death penalty can only be given by that guy. So, get ready for a mouthful. Bohemian v. Bush of 2008. And here, Labder, Bohemian, and 5 other Algerian natives were seized by the Bosnian police when U.S. intelligence suspected the group of involvement in a plotted attack on U.S. embassy soil located there. Bohemian filed for petition of writ of habeas corpus due to the alleged violations of the Due Process Clause, various statutes and treaties, common law, and international law. The question here is, are the detainees entitled to the protection of the Fifth Amendment to not be deprived of liberty without due process of law and of the Geneva Conventions? The answer is yes, that the detainees are entitled to protection of the Fifth because they were captured by U.S. militants and tried based on U.S. law. The policy impact here is that the case serves as a way for the judiciary to check the power of the executive branch, and the suspension clause of the Constitution was designed by the founders for this very reason of dealing with immigrants. Okay, in Solanas v. Texas, 2013, a man was questioned without being arrested and without being read his Miranda rights. He was questioned about this murder, and he decided to answer all questions until the one question that might have found him guilty, and he remained silent, was acting deceptive, and eventually the question comes to be, does the Fifth Amendment self-incrimination clause protect a defendant's refusal to answer questions before he has been arrested and read his Miranda rights? Conclusion: court decided that the Fifth does not extend to those who remain mute during questioning. They must first explicitly claim that protection. It was also found that the Fifth does not give the complete right to remain silent, but does guarantee that the defendant will not be forced to testify against themselves. Policy impacts: define the limits of the Fifth Amendment to protect only those who first ask for that protection.
Thank you all for joining. This concludes our search for criminal justice and what your criminal rights are. Please stay tuned because we have a special guest and he's going to let you all about what it means to work in the government. Please welcome Mr. Swanson.